Welcome back to the Two-Way Report. Bad news. Our friend's motion for a preliminary injunction in Mock v. Garland, FPC's case against the ATF's pistol brace rule, was denied. And the judge who denied it is the same judge who supported us in the Vanderstock case concerning the frame and receiver's rule, which is weird. The name of this judge is Reed O'Connor. I've been following him. He has been supportive of our cause in the past, but he did not side with us on his recent decision regarding the FPC's motion for a preliminary injunction against the ATF's pistol brace rule. I'll go over his decision so we are not weirded out. On page 1, under Introduction, the judge discusses the NFA and GCA and how the ATF has seen a rise in pistol braces since 2012, with some now resembling stocks and being used to avoid NFA regulations. Let's skip ahead to analysis part on page 6. I'm aware a lot of you hate lawyer speak, so instead of reading through it, I'll rephrase everything, using layman's term. The plaintiffs had multiple reasons for attacking the final rule. They argued that it violates their Second Amendment rights, chills their freedom of speech, and doesn't follow the due process guarantee of the Fifth Amendment. They also claim that it goes against the Constitution's structure and the Administrative Procedure Act, or APA. Specifically, they argue that it exceeds the ATF's authority under the APA and wasn't properly proposed. The court looks at these claims first to see if the plaintiffs have a good chance of winning before looking at the constitutional issues. The court is also checking if the final rule goes beyond the ATF's legal power or rights. The law says that if an agency does something beyond their legal limits, a court can stop or cancel it. The ATF has the responsibility to interpret and enforce laws related to firearms. Courts have recognized the ATF's authority in interpreting these laws. However, the ATF cannot redefine terms in a way that goes against the original law. In a previous case, the ATF redefined frame or receiver in a way that went against the law, and the judge references that case here. And lastly, that Chevron deference is when a court defers to an agency's interpretation of a statute. However, in the Fifth Circuit, this doesn't apply when the statute imposes criminal penalties or the agency is not asked to review in court. This came out of the Garland case, which was about bump stocks. So first, the plaintiffs argue that the final rule goes beyond the ATF's authority because the agency cannot interpret the term rifle, and even if it could, the interpretation goes against the term's plain meaning. However, the judge contends that courts have recognized the ATF's authority to interpret statutes with ambiguous terms, so it is not likely that the final rule exceeds the agency's authority because the statute includes ambiguous terms in defining a rifle. Second, the term rifle has a statutory definition that uses terms like designed, redesigned, remade, and intended, which require objective evaluation to determine if a firearm falls under NFA rules. The final rule sets out criteria for enforcement to make that determination, but it doesn't change the definition of a rifle. The plaintiffs haven't shown enough evidence to prove that the final rule contradicts the statutory definition of a rifle, so they haven't met the burden of showing a substantial likelihood of success on their APA claim. The judge then discusses the changes made in the notice of proposed rulemaking and the final rule, particularly the deletion of ATF Form 4999. While the judge doesn't believe this alone violates the APA, some people believe it does. Third, the plaintiffs argue that the final rule violates the Constitution's structural protections and the First, Second, and Fifth Amendments. The court first addresses the structural claims in which the plaintiffs argue that the final rule is an unreasonable construction of statutory terms and a clear example of the agency unlawfully creating law. However, the court finds these arguments unconvincing because the final rule interprets but does not rewrite the underlying statutes. Therefore, the plaintiffs have not shown that they are likely to succeed on the merits of their structural constitutional claims. The plaintiffs claim that the final rule violates their First Amendment rights because it allows agencies to regulate firearms based on statements made by manufacturers and other third parties. They argue that this would chill speech and force people to be cautious with what they say about protected arms. However, the court found these arguments unconvincing because the final rule does not prescribe speech, but rather allows the government to listen to what people say about the products they manufacture and purchase. Therefore, the plaintiffs have not shown they are likely to succeed on the First Amendment claim. Fifth, the plaintiffs say that the final rule is unclear and violates the Fifth Amendment's guarantee of fair treatment because the ATF can use certain factors to decide whether a gun falls under NFA rules. But these factors don't give clear guidance. To prove a law is void for vagueness, the complaint must show that the law is unclear in a way that makes it impossible for people to know what is expected of them. That is, the plaintiffs must show that the rule doesn't provide any standard of conduct at all, not just that it's imprecise. Per this judge, the 6 criteria used by the ATF to classify weapons are not perfect, but they still follow the statutory definition of what makes a firearm subject to certain laws. So, even though the criteria may be imprecise, they are still clear enough to inform people that their weapon may be subject to federal laws. Therefore, the plaintiffs have not shown that they are likely to succeed on their Fifth Amendment claims at this time. Next up, Second Amendment claims. Where a regulation implicates the Second Amendment, the government need only demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation in order to justify its enactment, and that's the Bruin decision. It does so by pointing to a well-established and representative historical analog. Plaintiffs raised two Second Amendment claims. The first claim was that the final rule violates their Second Amendment rights by regulating firearms with stabilizing braces. They argue that since these firearms are in common use, they cannot be banned. But this argument fails to convince the judge because the final rule does not ban the braces or the firearms equipped with them. Instead, it requires people to comply with the NFA's requirements, like registering the weapons with ATF or permanently removing the brace. Per this judge, traditional registration and licensing requirements are not the same as banning a firearm, and the Second Amendment does not prevent their imposition. And importantly, the final rule does not regulate stabilizing braces on their own, but only regulates the products when they are attached to a firearm. Indeed, the language of the final rule and of plaintiff's own briefing confirms this. Factoring criteria for firearms with attached stabilizing braces, and plaintiffs do not cite any language in the final rule that purports to regulate braces separately. Thus, the plaintiff maxim defense may still sell individual braces, and individual plaintiffs may still purchase them without being affected by the final rule. The plaintiffs have two more arguments. One, they argue that regulating gunsmithing, which includes adding stabilizing braces to pistols, has no historical precedent. So, the ATF cannot legally regulate it. And two, they argue that if the final rule is upheld, it violates the Second Amendment because stabilizing braces are commonly owned by Americans and deserve protection under the Constitution. The court somehow finds that there is not enough historical evidence to support the plaintiffs' arguments and that they are unlikely to succeed in their Second Amendment claims at this time. Therefore, they are not entitled to preliminary injunctive relief. Per the judge, the plaintiffs have not shown a strong chance of winning their case at this early stage, so they are not entitled to preliminary injunctive relief. This means that the court denies their request for now, and there is no need to consider the other requirements for a preliminary injunction. The decision was made on March 30th, 2023 by, again, Judge Reed O'Connor. This judge is making me scratch my head. He made a point that everyone, including Mock, Maxim, and Firearms Policy Coalition, missed the mark as far as this motion for a preliminary injunction. But a part of me wants to give this judge the benefit of the doubt. I think, based on the language he used in his order, he was giving our friends a gentle push. Kinda like, come on, you can do better than this. He did say that the plaintiffs could win on summary judgment, it's just that they didn't meet a high bar for a preliminary injunction. He needed better arguments from the plaintiffs to take down the ATF's rule, which they couldn't provide. I don't know if it's because they filed the lawsuit too soon after the rule was issued. We can only hope that the plaintiffs will have strong evidence to win at the summary judgment stage, that their arguments just didn't cut it for the preliminary injunction to be granted. This is sad. Who knows how long this case will drag on before our friends win on summary judgment? How many of us would have filed a Form 499 by then? And we've reached the end of this video. So, what do you think about this judge? Is he on our side? Is he on the ATF side? And do you want an update on this Mock v. Garland case? Let us know in the comments. Please like, share, subscribe, and click on that notification bell for more. Thanks and have a good one.